Earlier, we were talking about the disclaimer type of will, whereby if the surviving spouse disclaims an inheritance, the disclaimed property passes into a disclaimer trust. Then we were talking about the formula marital deduction type of will, where the will carves out the exemption amount and passes that exemption amount to a trust. Both trusts are for the benefit of the surviving spouse, but there are some key differences, and this slide is to try to help compare the two different types of trusts. Both trusts are designed to provide income for the spouse. Both of these trusts can be drafted to include other beneficiaries. This chart will show you the key differences. You'll note that both trusts can give the surviving spouse the power to withdraw 5% of the trust principal every year. If the surviving spouse needs more than the income and the 5% that can be withdrawn, then the trustee has the discretion to pay principal to the spouse. That doesn't mean the spouse can go in and grab the principal. It means that the spouse can ask the trustee for principal, and the trustee's job is to evaluate the request, determine whether it's reasonable, and determine how it affects other beneficiaries. Usually the other beneficiaries are the people who would inherit at the death of the surviving spouse. Let's talk about how the exemption trust that's created by the formula is different from the disclaimer trust. The surviving spouse can have the power to appoint the exemption trust property. That means the spouse can have the power to decide how the exemption trust property will go to the children and descendants or to anyone else except herself. The surviving spouse can have that power while she's alive, or it can even be exercised through the terms of her will. When it comes to the disclaimer trust, however, once the person disclaims property, and if a tax goal is the purpose of the disclaimer, then the person who's disclaiming the property could have no ability to determine who receives the property. That means the disclaimer trust cannot give the surviving spouse the power to appoint principal. That's a big difference. The formula marital deduction type of will creates a trust that gives the surviving spouse, or can give the surviving spouse, a lot more power over how the children and other descendants will receive the trust property. But the disclaimer trust cannot give the surviving spouse that type of power. Also, when it comes to the formula type exemption trust, the spouse can be a co-trustee. That's true also of the disclaimer trust, but if the surviving spouse is serving as trustee of the disclaimer trust, the surviving spouse cannot participate in any decisions to pay income and principal to any other trust beneficiary. And a little earlier we talked about how the disclaimer trust does not protect assets from the claims of the surviving spouse's creditors. On the other hand, the formula exemption trust can provide creditor protection. When we talk about estate planning, we like to alert people to mistakes that are frequently made. So in this portion of the video, I'd like to talk about each mistake, and I think you'll see that the mistakes too frequently relate to how the non-probate property is not properly coordinated with the terms of the will. So the first thing on the list is inappropriate decisions regarding non-probate property. We've already talked about much of this. We know that the jointly owned property with rights of survivorship will pass to the surviving owner no matter what the will says, so the will doesn't control that, and if you have too much jointly owned property, that could make the will ineffective. The same is true for in trust for accounts and transfer on death accounts, and life insurance beneficiary designations and retirement plan accounts. We've been through this already, so I'm not going to spend a lot more time on it, but I will be going into additional mistakes in the next segment.